Good morning, Ms. Francis.
Good morning.
I have not seen Ms. Jenkins as of yet. My policy is 15 minutes after the scheduled start time. If she hasn't arrived by 9:30, I'll get your case called and get you on with your day.
Thank you.
You're welcome. Mary Ann, would you send in 2301352, that's Van Buren Estates versus Williams and Youngblood? Would you put that in send that to the bench for me, please?
Yeah, maybe we can get 800 from them instead of just us do the 1,000.
Good morning, Ms. Hull.
Morning.
How are you, ma'am?
I am good, thank you.
We have Mr. Court here with Amani Givens. Do you need to speak to him before this case is called?
Mr. Is it an
Court
attorney?
from Lakeshore?
Yes, good morning, Ms. Hall. I just filed my appearance yesterday. I would appreciate a breakout room meeting if you would agree to it.
Okay, yes, that would be good.
Ms. Hall, I made you a co-host so you can move around.
Okay, thank you.
Welcome. There's a breakout room already with the name of Gunn on it.
This is 2301309 LT Holiday Woods versus Ellis. Your appearances, please.
Good morning again, Your Honor. Sydney Fontanella, P86316 for the plaintiff.
Attorney Jay McCurgy, P83218, appearing on behalf of the defendant.
Johnny
Thank
Ellis.
you.
Sorry.
Thank you. Today is the day and time for the second hearing in this matter. How are we proceeding?
Your Honor, we are requesting a 2-week adjournment. Mr. McCurgy has stated that he has filed an answer, appearance, and counterclaim, so I would like some time to review all of that.
When was that filed, sir?
This morning, Your Honor.
We'll put this matter over 2 weeks until November the 15th at 10 a.m. Anything else on behalf of the plaintiff?
I don't believe so, Your Honor. Thank you.
Anything else on behalf of the defendant?
None at this time, Your Honor. Thank you.
Thank you. That concludes this matter. I'll see you in 2 weeks. Have a good day, Mr. Ellis.
Thank you, Your Honor.
Have a good day, Your Honor. Thank you.
Thank you. This is 2301352 LT Van Buren Estates versus Lula Williams and Tyrell Youngblood.
Good morning again, Your Honor. Sydney Fontanella, P86316 on behalf of the plaintiff.
Thank you. Today is the day and time set for the second hearing in this matter. The case was scheduled at 9 o'clock. It's now 9:22 by the court's clock. Lula Williams or Tyrell Youngblood? No response. Defendants having failed to appear for a second time. Ma'am, how would you like to proceed?
Your Honor, I am requesting a default judgment as the defendants have failed to appear.
Plaintiff's request for default judgment is granted. Would you please have your office submit that for entry?
Yes, I will, Your Honor. Thank you.
Thank you, ma'am. Mr. Katz, this is 2301160 LT, the Maxwell versus Marlene Echols.
Good morning, Your Honor. I apologize for my tardiness. Cindy Katz on behalf of the plaintiff.
We lost Mr. Court. I'll come back to that one. 2301147 LT, the Maxwell versus Elizabeth Murphy.
Your Honor,
Elizabeth Murphy.
that's a dismissal, Your Honor.
Thank you. 2301149 LT, the Maxwell versus Ronaldo Copeland.
2 for 2, Your Honor. Dismissal.
Is that why you're late? 2301153 LT,
I
the
wish.
Maxwell versus Angela Williams.
3 for 3, Your Honor. Dismissal.
2301155 LT, the Maxwell versus Deshaun Smith.
Morning, Your Honor. Cindy Katz on behalf of the plaintiff.
Deshaun Smith. There being no response to the call, case having been scheduled at 9 o'clock, it now being 9:25 by the court's clock, defendant having failed to appear, Mr. Katz.
Your Honor, at this time requesting a default judgment. Currently, there's a balance due of $4,848 of past due rent, $155 of costs, for a total of $5,003, requesting a default judgment in that amount with the writ to be issued after November 13th.
Defendant having failed to appear, default judgment with that terms shall enter. 2301158 LT, the Maxwell versus Brittany Ortez.
Morning, Your Honor. Cindy Katz on behalf of the plaintiff.
Good morning.
Turn your video on and state your name, ma'am.
Brittany Ortez.
Thank you. Today is the day and time set for the second hearing in this matter. Mr. Katz, what is the rent to retain possession?
Your Honor, the rent is $3,851 of past due rent, $155 of costs, for a total of $4,006. At this time, requesting a judgment in that amount with the writ date of November 13th.
Ms. Ortez, were you able to hear Mr. Katz just now?
Yes,
Is the amount of rent claim due and owing accurate?
it is. I actually, on a couple days ago, I want to say 2 days ago, I paid $785 towards the balance. I'm paying an additional $500 today, which is what the office told me to state when I had asked, what do I let you guys know when I go to court?
Thank you. You do notify the court. Mr. Katz will make notation in his file that $785 was paid a few days ago and $500 was paid this morning. That does not change the amount of rent that is claimed as due and owing. And ma'am, in as much as there is not a defense to the non-payment of rent case, there is not a tribal issue of fact, and the plaintiff is entitled to entry of judgment in the amount requested. The 3851 in past due rent, 155 in court costs for a total of $4,006. He will, of course, verify those two payments with his clients and provide that updated information on the judgment he submits to the court.
Thank you, Your Honor. I will.
And Ms. Ortez, you will have 10 days to pay the balance.
Okay.
Anything else, Ms. Ortez?
No,
Thank you, ma'am. You're free to go. You have a wonderful day.
thank you. You too.
Thank you. This is a recall of 2301160 LT, the Maxwell versus Marlene Eccles.
Good morning, Your Honor. Sidney Katz on behalf of plaintiff.
Good morning, Your Honor. Raymond Cord on behalf of defendant, standing in place of attorney George.
Thank you. Mr. Katz, Mr. George was here earlier and indicated that there was a proposed consent judgment or conditional dismissal between the parties.
That is correct. I think it's a proposed consent judgment, and under the terms of the consent judgment, if defendant requests for a motion to set aside once the judgment has been satisfied, that we would agree to such a motion. If you want, do you want the terms on the record?
Yes, please.
Okay, so Your Honor, this is a non-payment of rent possession case. Currently, there's a balance due of $3,264 of past due rent, $155 of costs for a total of $3,419. Your Honor, I believe under the proposed consent, Ms. Eccles is to pay $1,000 by the 13th, with the remaining balance to be paid by the 27th. Is that correct, Mr. Court?
I believe so.
Ms. Eccles, have you been able to hear the attorneys just now?
Yes, I have.
And that's what you've agreed to, ma'am?
Yes, I have.
The attorneys will sign that consent judgment submitted to the court. Once I see it, I'll sign it, and then copies will be mailed to the parties at the addresses that we have on record. Is there anything else in this matter, Mr. Katz?
No, that should be it, Your Honor.
Anything else, Mr. Court?
No, Your Honor.
Thank you. Ms. Eccles, thank you for being so persistent and getting logged on and getting your audio connected this morning. You're free to go, ma'am. You have a good day.
Okay, all right, thank you. Have a wonderful
You're
day.
welcome. You too. This is 2301159 LT, the Maxwell versus Angel Bettis.
Good morning, Your Honor. Sidney Katz on behalf of plaintiff.
Hi, Your Honor. I'm here. Good morning.
Turn your video on and state your name, ma'am.
1 second. Hi, I'm Angel Bettis.
Thank you. Today is the day and time set for the second hearing in this matter. Mr. Katz, what is the rent to retain possession?
Your Honor, as of today, the current balance is $2,828 of past due rent, $155 of costs, for a total of $2,983, requesting a judgment in that amount with the writ date of November 13th.
Ms. Bettis, were you able to hear Mr. Katz just now?
He said with a rent date of November the 13th.
I mean, in regards to the past due rent in this matter.
Oh, yes. Yes, I understand.
Was the amount he claimed due an accurate amount, ma'am?
Yes, Your Honor.
Ma'am, in as much as you admit that the amount of rent claimed due is accurate, there's not a defense to this non-payment of rent case. There's not a tribal issue of fact, and plaintiff is entitled to entry of judgment in that amount. Mr. Katz's office will submit a judgment to the court with those dollar amounts on it. The court will sign it, and a copy will be mailed to you at the address we have on record. Is there anything else in this matter, Mr. Katz?
No, Your Honor.
Anything else, Ms. Bettis?
Your Honor, I would like to know how much time I would have to make a payment. I'm a auto worker, so we literally just came back off strike yesterday. So I'm just waiting for our signing. That's it.
Understood. Ma'am, what typically happens is the court does not get involved in the payment plans by and between the parties. The judgment that Mr. Katz's office submits will indicate that you have 10 days to pay or vacate the property. But what I always encourage tenants to do is to be in contact and communication with their property managers. Those are typically the people that set the payment plans.
Okay, even if my leasing office says that they don't do payment plans and that's something that I have to go through the court to do?
They don't do payment plans before the judgment, but once the judgment is entered, Mr. Katz, are you able to weigh in on this?
Yeah, I think sometimes that once they see that there's some payments or some form of activity, I mean, I can't guarantee that they'd agree to it, but I know that there have been situations where they have extended out the dates. So I would have that conversation with them as soon as possible.
Okay.
Ms. Bettis, if you reach out to them and they are not responsive to your efforts to get these past due rent paid up, you can, of course, always contact the court, submit something in writing.
Okay.
Okay. Anything else, Ms. Bettis?
No, Your Honor, that's all.
Thank you, ma'am. You're free to go. You have a wonderful day.
Thank you.
Thank you, Your Honor.
This is 2301267 LT Wellesley Townhomes versus Dominique Johnson.
Yes, ma'am. I'm present.
I'm just looking for Mr. Novak.
Oh,
Your Honor, did you have any more cases for me at 9? I think I should have 2 more.
I do, but when you come on
Okay.
at 9:20,
Just-
I'm not
no,
gonna
no,
make the 9:15 people wait,
I
that's
know.
all.
I know. I don't have any
Thank
right.
you.
Judge, I'm here. Robert Novak, appearing on behalf of the plaintiff.
Thank you. Today is the day and time set for the second hearing in this matter. Mr. Novak, what is the rent to retain possession?
$2,410 plus court cost.
What are your costs, do you know, Mr. Novak?
Judge, I don't have the service fee. Can you be of assistance to tell me what the service fee is? I was just looking for it as you called the case.
I cannot because this on-base system doesn't allow me to easily look at the dollar amounts.
How about if we use a $25 amount? That's probably
Ms.
lower
Johnson,
than
were
it
you able to
actually
hear
is.
Mr. Novak indicate that there's $2,410 in past due rent?
yes, I was.
Is that an accurate amount of rent, ma'am?
Yes, it is.
Do you have any defense to this non-payment of rent case?
I have another, I just was garnished. I have the money, well, I had the money, but I was garnished. I didn't know I was going to be garnished. Is that something to say or no? Does that allow me more? Can you hear
Does
me?
that allow you more? I'm sorry, ma'am, I can barely hear you.
I'm sorry, I have terrible service.
No, you're okay. I didn't hear what your explanation was. You said you were garnished and you asked, does that allow you more?
Well, that allows me to still the 10 days, correct?
It'll be 10 days to pay. Is that what you're asking?
Yes.
Yes, ma'am.
Okay.
Anything else, Ms. Johnson?
No, ma'am.
Mr. Novak will submit a judgment to the court that shows that there's $2,410 in past due rent, plus the court cost, the filing fee, the service fee. That will be submitted electronically. The court will sign it and the copy will be mailed to you at the address we have on file. Do you have any other questions, Ms. Johnson?
No, ma'am.
Thank you. That concludes this matter. You're free to go. Your judgment will be in the mail in a few days.
Thank you, Judge.
Thank you. This is 2301518 LT Integrated Property versus Kanisha Jenkins.
Good morning, Your Honor. Navjot Francis on behalf of plaintiff attorney of record.
Tanisha is here.
Kanisha Jenkins,
Yes. Do you hear me?
state your name, ma'am.
Tanisha Jenkins.
Today is the day and time set for the second hearing in this matter. Ms. Francis, what is the rent to retain possession?
$2,256.20 plus court costs of $214.30 for a total of $2,470.50.
Ms. Jenkins, were you able to hear Ms. Francis just now?
Yes.
Ma'am, is the amount of rent claim due and owing accurate?
Yes.
Do you have any defense to this non-payment of rent case?
No.
Ma'am, in as much as you are not asserting a defense to this case, there's not a tribal issue of fact, and plaintiff is entitled to entry of judgment in the amounts claimed due. Ms. Francis will have her office submit a judgment with those dollar amounts. The court will sign it, and a copy will be mailed to you at the address we have on record. Anything else in this matter, Ms. Francis?
Your Honor, this was also for a money judgment as well.
I'm sorry, ma'am, I can't make out what you're saying.
Sorry, this was also for a money judgment.
Yes, ma'am.
Thank you.
Thank you. Anything else, Ms. Jenkins? Thank you, Ms. Francis. Have a good day.
Thank you, you too.
Thank you. This is 2301336 LT, Romulus Housing versus Anissa Gaitan.
Morning, Your Honor. Steve Hitchcock on behalf of the Romulus Housing Commission.
Mr. Hitchcock, this case was scheduled at 9:15. It's now 9:37 by this court's clock. You're not getting a response to the call. How would you like to proceed this morning?
I'd like to proceed with a default judgment, and the rent owing is $774, and we have $94 in costs for a total amount of $868.
Thank you. The court will enter default judgment in that amount. Please have your office submitted to the Civil Department for entry. Thank you. Ms. Korabi? We're running just a skosh behind schedule. If you see any of your tenants having checked in, if you want to grab them, move them to a breakout room and discuss their cases with them, please do so. I'm still on the 9 and the 9:15 call.
Sounds great, Your Honor. Thank you. I will look for them.
Thank you. This is 2301279 LT, Romulus Housing versus Malik Jones and all other occupants.
Morning, Your Honor. Steve Hitchcock on behalf of the Romulus Housing Commission.
Malik Jones or any other occupants? Mr. Hitchcock, this case was scheduled for a second hearing today at 9:15. It's now 9:38 by the court's clock. Defendant having failed to appear and no one else responding to the call. How would you like to proceed this morning?
I would ask for a default judgment. This was based on a 30-day notice to quit, so there's no rent involved in this case.
Defendant having failed to appear, default judgment shall enter in favor of plaintiff and against defending, restoring possession to Romulus Housing. Mr. Hitchcock, please have your office submit the appropriate paperwork. Anything else in this matter?
Nothing further. Thank you, Judge.
Thank you, sir. Have a good day.
You too.
Thank you.
Your Honor, I'm sorry to interrupt, but I don't see how I can move myself to a breakout room.
I thought Marianne had already made you a co-host. If she has not, we will do that now.
She is.
And you have rooms assigned to you.
Okay, thank you.
I'm sorry, Marianne, what did you say?
I said that she already is a co-host.
Thank you.
Not to interject, but I'm a co-host as well. It seems that it's not allowing us to move people from the clerk waiting room to the attorney waiting rooms right now.
Okay, going forward, if you have an issue like that, you can send Marianne a chat and she'll help you get your people where you're supposed to go. But we'll right now, let's look at the 9:30 docket. And Marianne, if there are people that need to go, they can go. Mr. Wojcik, thank you. You're part of the 9:15 call. I'm prepared to start calling those cases. If you want to move, you can move, but I'm more inclined to just get these cases called.
That's just fine with me. I believe there's only one 9:15, Mr. Brown, and that's a dismissal.
Mr. Curtis Brown?
Yes.
And 2301272 LT Southport Apartments versus Curtis Brown. Yes, Mr. Wojcik, I saw there was no service in the file, but you're vindicated that the case is being dismissed?
I was unaware that there was a service issue, but yes, my client is requesting that we dismiss Mr. Brown. I believe it was e-filed yesterday, so it might not have caught up.
Mr. Brown, were you able to hear that conversation with the attorney just now?
Yes, Your Honor.
This case is being dismissed, sir. Unless you have anything else or any objection to the dismissal, you're free to go.
No, Your Honor, I do not.
Thank you, sir. You have a good day.
Thank you. You too.
Thank you, Mr.
Thank
Brown.
you. This is 2301161 LT, the Maxwell versus Jeremy Robinson, Gerame.
I know how to exit here.
Good morning, Your Honor. Sidney Katz on behalf of plaintiff.
Robinson.
Your Honor, that's a dismissal.
Today, Mr. Katz.
I think we filed them. I don't know why it's not showing up, but
Well, I looked at 2 days ago, so
Oh,
if the
okay.
dismissal hit my on base yesterday, and I wouldn't have seen it. This
Okay.
is 2301162 LT, the Maxwell versus James Walker.
Morning, Your Honor. Sidney Katz on behalf of plaintiff.
James Walker. Today is the day and time set for the second hearing in this matter. Case was scheduled at 9 o'clock. It's now 9:42 by the court's clock. Defendant having failed to appear, Mr. Katz.
Your Honor, this is a non-payment rent possession case, second hearing at this time, requesting a default judgment. Currently, there's a balance due of $4,965 of past due rent, $155 of cost, for a total of $5,120, requesting a default judgment in that amount with the writ to be issued after November 13th.
Default judgment shall enter with the terms just placed on the record by Mr. Katz. Mr. Katz, in reviewing the case on base, your complaint lists a dollar amount with 11 numbers after the decimal point. Just something for you to look at later in reviewing the files. I just found it I hadn't seen that happen before with your filing, so I'm not sure what happened.
Yeah, it probably should have been refiled, Your Honor. I think we might have had an amended. What happens is in our system, if you put cents in it, it messes the whole thing up. So we're not supposed to put the cents in. And when they do, that's what happens.
Thank you. This is 2301275 LT, Pinewood Circles versus Tanisha Chandler.
Good morning, Your Honor.
Tanisha
Sidney Katz.
Chandler.
Yes. Yes, Your Honor.
State your name, please.
My name is Clinton Boyd on behalf of Tanisha Chandler. I am the other occupant on the lease.
You're the occupant on the lease.
Yes, it's two of us names on the lease. Tanisha Chandler.
Where
and
is
Clinton
Miss
Boyd.
Chandler?
Miss Chandler could not make it to the call. I just called in this morning to get the number. We didn't get a listing for today's call at 9 o'clock. I do apologize.
I'm sorry, she can't make it.
Yes.
Where is she, sir?
She's in school at the moment.
Thank you. She's the named party, which is why I'm asking. Mr. Katz, what is the rent to retain possession in this matter?
Your Honor, currently there's a balance due of $6,386 of past due rent, $155 of cost, for a total of $6,541, requesting a judgment in that amount with a writ date of November 13th.
Mr. Boyd, were you able to hear Mr. Katz just now?
I heard half of that. Can I get the total again? And what was that date?
$63.86 in rent, $155 in court costs, for a total judgment of $6,541. It will be a pay or vacate by November the 13th.
Okay.
Is the amount of rent claim due and owing accurate, sir?
Yes.
What will happen, sir, is because there's not a tribal issue of fact, the plaintiff is entitled to entry of judgment in the amount requested, as Ms. Chandler is the sole named party on the complaint filed in this case. This judgment will enter as a default as to her, and a copy will be mailed out to the address we have on record. Anything else, Mr. Katz?
No, that's it, Your Honor.
Anything else, Mr. Boyd?
No.
Thank you, sir. You're free to go. You have a good day.
All right. Thank you. You too as well.
Thank you, Your Honor. And I think that's it for me. I apologize again.
Thank you, Mr. Katz. Take care.
Thank
No
you.
worries. This is 2301281 LT, Parkwood Manor versus Liza McElwee and Kayla McElwee.
Dana Hall on behalf of Parkwood.
Yes, we're here.
Yes. State your names, please.
Kyla McElwee.
Liza McElwee.
Thank you. Today is the day and time set for the second hearing in this matter. Ms. Hall, what is the rent to retain possession?
It's $5,177 and the costs are $261 for a total of $5,438.
Were you ladies able to hear the amount of rent claim owing in this matter?
Yes.
Is that amount accurate?
Yes.
Do you have any defense to this non-payment of rent case?
Well, I had to I'm the one that's working, Liza McElwee, and my daughter Kyla here is not working. I had a big garnishment on my record, and I want to ask the court today if I'm able to pay November rent today and get on the payment plan if that's possible, have all monies due this month.
Ms. McElwee, unfortunately, the court does not get involved in payment plans between landlords and tenants. What the court will do is, if there's not a defense to the non-payment rent case, there's not a tribal issue of fact, the plaintiff is entitled to entry of judgment. What the court would encourage you to do is to be in contact and communication with your management office, your property leasing agent, whatever they call themselves, and set up payment plans directly with them. If they are refusing to accept payments with you, that would be the only time the court will get involved in this matter. The attorney has placed on the record the amount of rent claim due and owing plus the court cost. The total is $5,438. They also submitted a request for entry of a money judgment. The court will grant that request. So once you get a copy of the judgment, if you have any questions or if you aren't able to make payments, your property management office will not accept payments. You reach back out to the court. But other than that, the judgment will enter as indicated on the record. If there's a financial issue because of the garnishment, Ms. McElwee, there are rent assistance programs available through Wayne Metro, which is in the building right next door to the court.
Okay.
Anything else, Ms. Hull?
No, Your Honor.
Anything else, Ms. McElwee?
No, not at all.
Thank you. That concludes this matter. You're free to go. You have a good day.
Thank you.
You too.
Thank you. This is 2301284 LT Parkwood Manor versus Jandy Sleece.
Dana Hall on behalf of Parkwood.
Last name is Tlais. Today is the day and time set for the second hearing in this matter. This is defendant's second failure to appear in this case. Ma'am, how would you like to proceed?
And we'd like to request a default judgment. I do not know. We filed for a money judgment. I do not know if she was personally served. I'm not sure if the court's able to see that.
Posting. Okay. Served by posting.
We got it. At this time, the past rent is $4,923.50. The costs are $233 for a total of $5,156.50.
Default judgment will enter in that amount. Please have your office submit the judgment for entry.
Okay, thank you.
This is 230176 LT Parkwood Manor versus LaWanda Wilson.
Dana Hall on behalf of Parkwood.
Good morning, Your Honor. Jeanette McLemore appearing on behalf of LaWanda Wilson, and Ms. Wilson is also present on the call, Your Honor.
Thank you. Ms. McLemore, did you file an appearance in this matter?
I believe that I did file an appearance in this matter, yes.
I did not see your name. Did you need to speak to Ms. Hall regarding this matter?
Yes, an appearance should have been filed on the 24th. Yeah, that's what my
Ms.
record.
McLemore, it's
Yes.
okay. I'll update it on my end. Do you need to speak to the attorney for Parkwood?
It would not hurt, Your Honor. That would be good. Thank you.
Let's get you into a breakout room with her. Ms. McLemore, we'll see you into Ms. Hall's room, but let me call the remaining cases that she has scheduled from the 9:15 docket. There is 2301171 LT Parkwood Manor versus Amani Givens.
Dana Hall on behalf of Parkwood.
Good morning, Your Honor. Raymond Corda on behalf of Amani Givens.
Amani Givens here.
Thank you. Mr. Court, my apologies. I lost track of you on this case. The parties have had the opportunity to speak. How are we proceeding?
Your Honor, we have an agreement at this time. We will be submitting a conditional dismissal with the amount to be paid by November 17th.
And that amount is?
I know that the past due rent is $5,580. I just have to find out what the service fee is to add the cost.
Mr. Court?
Yes, Ms. Givens has applied for rental assistance, so we just need the final number to submit to MDHHS. So that would be the accurate amount.
Thank you, sir. I'll make the notes in the file that we're anticipating a receipt of the conditional dismissal with the past due rent of $55.80 and whatever the service cost is determined to be. Copies will be mailed to the parties at the addresses we have on record. Is there anything else in this case, Ms. Hull?
No, Your Honor.
Anything else, Mr. Court?
No, Your Honor.
Thank you. Ms. Givens, you're free to go. You have a wonderful day. Thank you for your patience this morning.
Thank you. You too.
Thank you. 2301770 LT Parkwood versus Mahogany Love.
Dana Hall on behalf of Parkwood.
Mahogany Love is present.
Thank you, Ms. Love. Today is the day and time set for the second hearing in this matter. Ms. Hull, what is the rent to retain possession, please?
$7,725. The costs are $233 for a total of $7,958.
Ms. Love, were you able to hear the attorney just now?
Yes.
Ma'am, is the amount of rent claimed due and owing accurate?
I'm assuming so.
Don't assume so, ma'am. If you have questions about it, let's talk about it.
Yeah, there was a leftover balance of this was a while ago, but it was like $4,000 that carried over. So it was an issue with, where that came from. Like, it was never brought up or anything. I didn't know about it until I tried to pay my rent online, and it said that I had a balance of $4,000. So that was a whole
Ms. Love, that sounds like a dispute. So let's do this. Ms. Hull is going in to speak to an attorney about one case. She'll speak to you about this case. If you don't reach an agreement with her, we'll have her get her client, get the ledger. We can figure out have a hearing and figure out what the exact balance should be, okay?
Okay.
So Ms. Hull will go in with Ms. McLemore, and then we'll get you in with her.
Okay, thank you.
Thank you. This is 2301058 LT. This is Trilogy versus Terrell Davis.
Laura Kruby, Your Honor, on behalf of the plaintiff.
Terrell Davis,
Yes, I'm here.
turn your video on, state your name for the record, sir.
Yes, Terrell Davis.
Thank you. Today is the day and time set for the second hearing in this matter. Ma'am, what is the rent to retain possession?
Your Honor, rent to retain possession is $3,123.63, plus court costs of $168.28 for a total of $3,291.91.
Mr. Davis, were you able to hear the attorney just now?
Yes, ma'am.
Are you driving, sir?
I'm in the car.
Are you behind the wheel of the car, sir?
No, I'm sitting in the driver's wheel. I'm sitting in the driver's seat.
Was the amount of rent claimed due and owing by the plaintiff correct, sir?
Yes.
Do you have a defense to this non-payment of rent case?
I don't have a defense, but I did speak with someone at the first court date, and I have a check in the mail that's in my informed delivery today for $4,500, which is including this month's rent as well. So the payment will be in full today because I can't make money order payments to the apartments. I have to pay them by check.
That Mr. Davis, what will happen is because there's not a defense to the non-payment of rent case, the plaintiff is entitled to entry of judgment in the amount they claim, $3,591.91.
Correction, Your Honor, $3,000.
I'm sorry, that's not right.
$291.
$3,291.91.
Yes.
Okay, thank you, ma'am.
And Your Honor, just a question. Is this a consent judgment or judgment by hearing?
Judgment by hearing.
Thank you.
And Mr. Davis, is your assertion that there's $4,500 that is going to be paid to your landlord?
Yes, I'm looking at it. I'm looking at it in the mail right now on my informed delivery. The check is there. So
So yeah,
Then
they'll
what'll
have it
happen,
today.
Mr. Davis, is that you'll get the judgment that says that it's 3291. Once you get that payment in, just confirm that they've received that payment and it will zero, you know what I mean? The judgment will say one thing, but you'll know that the payment's coming.
Oh yeah, I'm taking in there personally, so I'll know it's zeroed out and I'll have a copy and everything.
Good. Keep your receipt with the document, but the judgment will say that you'll have 10 days from today's date to either pay or vacate. So keep your receipt that you've caught up the payments, okay?
Okay.
Anything else, Mr. Davis?
No, thank you.
Thank you, sir. Have a good day. You're
Thank
free
you.
to go.
You too.
Two 3012650T Edward Jones versus Messiah Lutheran Church.
My name is Bill Hales, Your Honor. I'm here for Messiah Lutheran Church.
Thank you, Mr. Hills. The attorney for Edward Rose is here. Maybe he's in with someone else. We'll get you connected here shortly.
Okay. Thank you.
Thank you. This is 2301059LT Trilogy versus Anderson and Green Earby.
Laura Krug, Your Honor, on behalf of plaintiff.
Is there anyone here for Atalia Anderson or Ayana Green Earby? Today is the day and time set for the second hearing. This case was scheduled at 9:30. It's now 9:57 by the court's clocks. Defendants having failed to appear. Ma'am, how would you like to proceed?
Your Honor, plaintiff would like to move forward with a default judgment as to both defendants for possession only, rent to retain an amount of $4,205.74, court costs of $204.91 for a total of $4,410.65 with a writ to issue in 10 days.
Thank you. The court will enter that judgment upon presentation.
Thank you.
This is 2301060LT. This is Trilogy versus Jenny Caldwell.
Laura Krug, Your Honor, on behalf of plaintiff.
Ms. Caldwell, you're muted, ma'am.
All right, can you hear me now? I apologize, Your Honor.
Don't apologize, ma'am. Of course, I can hear you now. Yes, thank you. State your name for me, please.
Jenny Caldwell.
Ms. Caldwell, today is the day and time set for the second hearing in this matter. What is the rent to retain possession, ma'am?
Your Honor, rent to retain is $3,606.47. Court cost is $168.28 for a total of $3,774.75.
Ms. Caldwell, were you able to hear the attorney just now?
I am, and since it's November 1st, would my other rent be added as well? How does that work? I just want some clarification on that.
I do not know if your rent was added. Just give me a moment, please. I don't see your rent being added to this judgment.
Okay. And can I get that amount again? I apologize. Give me one moment.
Take your time.
I'm sorry, ma'am. Did you say that the $3,606 does not include November rent?
I don't believe. Actually, give me one moment, Your Honor. That's correct. I don't have an updated ledger that includes the November on here.
And how much is that amount again?
$3,606.47. $6.47 in past due rent, $168.28 in court costs for a total of $3,774.75. And the attorney is indicating that that does not include the November rent.
Okay, I wanted to address the court regarding I've had 2 major surgeries since April, and I'm trying to get my finances back in order. My last surgery was July 28th, which I only was getting 60% of my income. And I'm wondering if I can ask the courts for an extension as of the 6th to pay in full by the 17th. I just picked up a second job to help come up with this money. And I have nobody that I can ask for help.
Want to do a short intake process, make sure you.
I'm sorry, I've lost connection somehow.
No, you didn't lose connection. You're fine. Miss Kohlrabi,
Yeah.
the 17th.
She said she wants
Your
until,
client allowed, I'm sorry?
she said she wants until November 17th.
Correct.
Yes, ma'am.
It's okay, Your Honor.
I also
Thank
want to
you.
address something else. So I've been a tenant for 4 years, and they implemented something new this year. If you don't have renter's insurance, that I get a fee of $19 added to each month of rent. I've had insurance as long as I've lived there, and I've incurred at least $45 in fees that I don't believe I should have to pay. I have proved every lease renewal that I have had carried that renter's insurance that is required. And I just want to know if I can get those fees waived, because I don't feel like I owe it.
Okay, ma'am, if you're disputing the amount of rent, what we'll do is we'll pass the matter for a moment. Ms. Kohlrabi will need to produce the ledger and her client. We can have a hearing in this matter.
Can we do that, please? Because I want to make sure that, I mean, I've always followed, I've just had this year has been rough on me, and I'm just trying to get myself I'm just trying to get everything back lined up, and I apologize. I did not want to be in this position.
You don't need to apologize, Ms. Caldwell. We all have stumbles, and it sometimes takes us a while to get back on track. But what we'll do is, if you're disputing the amount of rent, my question to Ms. Kohlrabi will be, how long do you need to get your client on with the ledger?
Your Honor, if you could just give me about 5 minutes, I will call my client and to get an updated ledger.
Ms. Caldwell, we'll pass this matter momentarily. Ms. Kohlrabi will speak to her client, get them on. We'll figure out what adjustments need to be made regarding this renter's insurance, okay?
Okay.
Thank you, ma'am. Just be patient. This is a recall of 2301769 Parkwood versus Wilson.
Good morning, Your Honor. Jeanette McLemore, appearing on behalf of LaWanda Wilson.
Dana Hall on behalf of Parkwood.
Your Honor, I did have an opportunity to speak to Ms. Hall, and as I explained, I would like to schedule this matter for a trial, and also I'd like to file an answer in this matter. Ms. Wilson does have some issues regarding repairs. I have photographs and other information of a list of repairs that she shared with management that have not been taken care of, and we would like to pass that information on to Ms. Wilson, and perhaps the matter can be resolved.
Will you be ready on November 15th at 9 a.m.?
November 15th at 9 a.m. I believe that is a good date for me, Your Honor. Ms. Wilson, is that a good date for you?
It's gonna have to be.
And I guess Ms. Hall?
Yes, that's good for me.
If there are documents that you want the court to review and consider, please submit them to the civil department at least 3 days before the hearing to allow time for them to get upstairs and into the electronic file.
Yes, Your Honor.
Okay.
Anything else on behalf of the plaintiff?
No, Your Honor.
Anything else on behalf of Ms. Wilson?
No, Your Honor.
Thank you. Back on Zoom on November 15th at 9 a.m. Have a wonderful day.
Thank you, Your Honor.
Thank you.
Thank
Ms. Hull, did you ever get connected with Ms. Love?
No, I did not.
Let's get you into a breakout room with her, please. This is 2301248LT Westlake Apartments versus Kayla Donnelly.
Good morning, Your Honor. Ryan Wojcik, P84535 on behalf of the plaintiff. And we do have Miss Donnelly. It appears she's muted.
She's represented by Mr. Court. Aren't you, Miss Donnelly?
If I may, Your Honor.
Absolutely.
I just spoke to Mr. Court. He invited Miss Donnelly to a breakout room, but she has not accepted that request. So I don't know if we can move her in with the breakout room into the breakout room. I did speak with her briefly before I knew she was represented and have spoken with Mr. Court, so we just want to see if my proposal is accepted.
Thank you. Mary Ann will try to get her moved into a breakout room.
Thank you.
This is 2301251 LT Westlake Apartments versus Marquise Wilcher.
Good morning again, Your Honor. Ryan Wojcik, P84535 on behalf of the plaintiff.
Marquise Wilcher. Today is the day and time set for the second hearing in this matter. Case was scheduled at 9:30. It's now 10:06 by the court's clock. Defendant having failed to appear. How would you like to proceed, sir?
Your Honor, at this time, we are requesting a default judgment of possession only. Rent to retain of $7,554.50. Cost of $164 for a total redemptive amount of $7,718.50. Requesting a writ date of November 13th, 2023, and Mr. Herman's office will prepare a judgment and submit it to the court.
Thank you, sir. This is 2301262 LT. This is Westlake Apartments versus Diane Land and Consuela Calloway.
Hello.
Good morning again, Your Honor. Ryan Wojcik on behalf of the plaintiff.
State your name, ma'am.
I'm Consuela Calloway.
Miss Calloway, where's Diane Land? Do you know?
That's my mother. She passed.
Oh, my apologies, ma'am. There was no update in the file regarding that. Today is the day and time set for the second hearing in this matter. What is the rent to retain possession, sir?
Your Honor, the parties have agreed that rent to retain is $4,607.17. Cost of $198 for a total redemptive amount of $4,805.17. I did have a chance to speak with Ms. Calloway, and the parties have agreed to enter into a consent judgment.
Ms. Calloway, were you able to hear the attorney just now?
Yeah.
Ma'am, was that an accurate statement of the agreement that you reached with him?
Yes.
And you wish to enter this as a consent judgment?
Yes.
And ma'am, you understand that because he represents your Westlake Apartments and you're not represented by an attorney, the judgment will not be final and enforceable for 3 days.
Yes.
Do you have any questions at all, Ms. Calloway?
No.
Ma'am, because you appear on Zoom, there is not a signed consent judgment. Have you authorized the attorney's office to sign your name to a consent judgment with these terms?
Yes.
Ma'am, Mr. Herman's office will submit a consent judgment with those terms. The court will sign it and a copy will be mailed to you at the address we have on record. Is there anything else on behalf of the plaintiff?
No, Your Honor. Thank you. Thank you, Ms. Calloway.
Thank you both.
Anything else, Ms. Calloway?
No, thank you.
Thank you, ma'am. You have a great day.
You too.
Thank you. 2301265 LT Edward Rose versus Messiah Lutheran Church.
Good morning again, Your Honor. Ryan Wojcik, P84535 on behalf of the plaintiff. And Your Honor, we do have a representative from the church. He is not an attorney, but he did appear at the pretrial and appears today.
Thank you. Mr. Hills? Unmute yourself for me, please, sir.
Hello, Your Honor. This is Bill Hales.
Good morning, sir. What is your position with the church, sir?
I'm the pastor of the church.
Is the church represented by an attorney, sir?
That was one of the reasons, one of the questions I had today is we're trying to get an attorney to represent us. We just need a little bit more time. So I wanted to ask the court for more time to get that worked out.
If I may, Your Honor.
Yes, sir.
I did appear at the pretrial. At that time, I did tell Mr. Hales, I believe that a church would need an attorney to appear at the hearing. And I believe Mr. Hales also spoke with legal aid, where I assume they told him the same thing. So he's had plenty of time. The church has had plenty of time to secure an attorney and has failed to do so. We are requesting a default judgment.
I never had a connection with legal aid.
Mr. Hales, have you been in contact with an attorney as of yet?
Not at all. We just need a little bit more time to speak with someone.
What's a
Mr.
little bit more time, sir?
2 weeks.
Good job.
Over the plaintiff's objections, the court will put this matter over for 2 weeks. We'll put you on that November 15 docket at 9 a.m. If you are not represented by an attorney by that point, if the church is not represented by an attorney at that point, sir, the court will entertain the plaintiff's request for entry of judgment.
Thank you, Your Honor. Thank you, Mr. Hales.
Thank you, Mr.
Anything
Thank you,
else,
Your
Mr.
Honor.
Hales?
No, ma'am. Thank you, Your Honor. I appreciate
Thank you,
it.
sir. You're free to go. You have a wonderful day.
You too. Thank you, Your Honor.
Thank you. Mr. Court, are we ready on Donnelly?
If I could just have 1 minute with Attorney Wojcik, I think we're going to have a resolution. I just need to work out what route it'll take.
Absolutely, sir. Let's get you into a breakout with him.
Thank you.
Thank you.
Thank you. Ms. Jenkins.
Yes, Your Honor.
This is 2-3-01518 LT, Integrated Properties versus Jenkins.
Hello.
Ma'am, this case was called earlier. Is there something else I can do for you?
I wasn't here for the resolution. My phone died as I was in court.
I thought the conversation was that there's $2,276.20 in rent due and owing, $214.30 in court costs for a total of $2,470.50.
Yes.
Plaintiff is submitting a judgment with that dollar amount. And you'll have 10 days to pay that amount or vacate the property.
Okay.
Ma'am, did you need financial assistance with paying that rent?
No.
You're free to go. You have a good day.
Thank you.
Thank you. Ms. Miller? Ms. Kohlrabi? Ms. Caldwell?
Yes, Your Honor.
Did you have a chance to speak to the attorney?
I have not. Can I ask for can I ask for another hearing on the 15th to settle with the ledger and figure out this balance?
Let's get her attention and what we'll do. Ms. Kohlrabi?
Hello, I apologize
Did
about
you
that.
just? I'm sorry.
I apologize. I have not been able to get a hold of anyone in any management to get an updated ledger. So I believe if there is a dispute, then we will have to schedule this for another hearing, if that's okay with you.
Exactly. That's what Ms. Caldwell just asked for. This is 2-3-0-1-0-6-0 LT. We'll put this matter over to 10:30 on November the 15th. In the interim, if you could have someone send Ms. Caldwell a copy of the ledger, and Ms. Caldwell, if the issue is your dispute, please be prepared to present your documentation regarding the disputed amount on that 15th.
Okay, that sounds good.
I would like documents that you want the court to consider.
I understand. I was going to just ask, can I pick that ledger up in person at the office? If I could request management office to let me pick that up in person, I would appreciate that.
Of course. Go ahead. I will let them know if I don't get a hold of them, just go in and request it. Oh, and she just go ahead, go into the office and request an updated ledger.
Okay, that sounds good.
Anything else, Ms. Caldwell?
No, that'll do it. I think this is, I think everything's, I'll look forward to meeting again on the 15th to settle this.
Thank you, Ms. Caldwell. You have a good day.
All right, thank you, Your Honor.
Thank you. This is 2301064 LT Trilogy versus Jalen Gaddis.
Laura Kuby, Your Honor, for the plaintiff.
Jalen Gaddis, this case was scheduled at 9:30. It's now 10:16 by the court's clock. Defendant having failed to appear. Ma'am, how would you like to proceed?
Your Honor, at this time, plaintiff would like to move forward with a default judgment for possession only with rent to retain in the amount of $3,845.21. Court cost of $168.28 for a total of $4,013.49 with a writ date in 10 days.
Court will enter default judgment as indicated on the record. 2301076 LT Trilogy Residences versus Jennifer Jones and Tyrese Wright Jones.
Laura Kuby for the plaintiff, Your Honor. This is actually a dismissal. I believe it was sent in yesterday.
Thank you, ma'am. 2301102 LT Trilogy Residences versus DeAndre Wilson.
Your Honor, this is also a dismissal.
2301176 LT West Village Estates versus Latina Smith.
Your Honor, that is also a dismissal. And Laura Kuby on behalf of plaintiff.
Thank you. Holy smokes. Anything else?
Your Honor, I believe my next ones are at 10:45, so I'm just going to mute myself and wait.
Thank you,
I'm
ma'am.
actually here. I have an appointment at 10:30. My name is D'Angelo Funches.
Mr. Funches, thank you. Sit tight, sir. We'll get to you momentarily.
Okay. I just didn't know if I could go early because I am currently
You
at work.
can't, Mr. Funches, you can go early, but let me get the 9:30s done first, okay?
Oh, okay. I'm sorry. I was just.
Thank you. No worries.
Okay.
This is 2301248 LT Westlake versus Donnelly.
Good morning again, Your Honor. Ryan Wojcik, P84535, on behalf of the plaintiff.
Good morning again, Your Honor. Raymond Court, Lakeshore Legal Aid, appearing on behalf of Ms. Donnelly, who's also present on Zoom.
Thank you. How are we proceeding this morning in this matter?
Thank you, Your Honor. I did have a chance to speak with Mr. Court. The parties have agreed to enter into a conditional dismissal. I'm happy to place those terms on the record.
Thank
you.
you.
That is rent to retain of $3,779.25, cost of $164 for a total of $3,943.25. That amount is to be paid in full, or defendant is to vacate by November 13th, 2023. Otherwise, landlord can request a reinstatement of case, entry of judgment, and writ under 4B. Partial payment would not prevent eviction. I'm actually drafting that conditional dismissal right now, and I will send that over to Mr. Court for signature. We will e-file with the court.
Thank you. Mr. Court, is that an accurate recitation of the agreements reached by the parties?
Yes, it is.
Thank you. I will await receipt of that executed conditional dismissal. Anything
Thank
else on behalf of the plaintiff?
No, Your Honor. Thank you.
Anything else on behalf of the defendant?
No, Your Honor. Thank you.
Thank you. Ms. Donnelly, you're free to go. You have a wonderful day, ma'am.
Thank you, Your Honor.
And I believe that was my last matter, Your Honor, so have a great rest of your day.
You too, sir. Thank you. Ms. Miller.
Good morning, Your Honor.
Good morning, ma'am. In 2300976 LT Barbara Rogel Miller versus Ellen Watson, the court has not received a proof of service in this matter.
Yes, Your Honor. I tried to call the court yesterday to say that she moved out and that it was not necessary. It was that I wanted to dismiss the case. And I was told to e-file my dismissal, but I'm inept on doing that. So I will file it after this hearing, Your Honor. I'll figure it out.
Thank you so very much, Ms. Miller. I'll make a notation on the file that the dismissal is coming. Anything
Thank
else
you,
this
Your Honor.
morning?
Thank you.
Thank you, ma'am. Have a good day.
And you too, Your Honor. Thank you.
Thank you. Two 301-411 LT. This is 41254 Woodbury Green versus Chania Arnott. This case was scheduled at 9:30. It's now 10:22 by the court's clock. Neither party has appeared. This case will be dismissed. This is a recall of 2301770 LT Parkwood versus Love. The parties have had the opportunity to speak. How are we proceeding in this matter?
Your Honor, Ms. Love and I agreed to do a conditional dismissal. We extended the date to pay 90 days. So because of that, I added December rent, January rent, and Ms. Love said she will pay $772 a week until through January 30th, starting this Friday.
Ms. Love, were you able to hear the attorney just now?
Yes.
And that's your agreement, ma'am?
Yes.
And you understand that because she represents the apartment and you're not represented, the judgment will not be final and enforceable for 3 days?
Yes.
And you have 10 days to appeal the decision of the court.
Okay.
And ma'am, because you appear by Zoom and not in person, there is not a signed conditional dismissal. Have you authorized Ms. Hall or her office to sign the the conditional dismissal on your behalf? Or will you be circulating the document for signature? Thank you. Anything else, Ms. Love? I'm sorry.
No, I was gonna say, yeah, I authorize it, but yeah, no, nothing else.
Thank you, Ms. Love. You're free to go. I will await receipt of that conditional dismissal.
Okay, I'll submit it. Thank you, Your Honor.
Is that it for you, ma'am?
Yes.
Thank you so much. Have a good day.
You too.
Oh, not Kevin Callahan. Mr. Patton, take your cap off for me, please.
Yes.
Thank you.
Okay. 3 1/4 Redo. Okay.
Mr. Court, did you have something else, sir?
Yes, Your Honor. My client for 1030 is present, Adisa Baba.
Sir, did you need to speak? Or have we seen the attorney yet for the plaintiff?
I have not seen plaintiff's attorney this morning.
Okay, well, give us, let's go through some of these other cases and see if this attorney for the plaintiff appears. Otherwise, I'll get to you as soon as I can, Mr. Court.
All right, thank you, Your Honor.
Thank you. This is 2301129LT. This is Harbor Club versus Patton. May I have your appearances, please?
Yes, I'm here.
Your
And
Honor,
you
for the
are-
record, I'm sorry, I was gonna put my formal name in the record. Your Honor, Attorney Ian Morton, Palace Law, on behalf of the plaintiff P67892.
State your name, sir.
Dennis
Mr.
Patton.
Patton. Thank you. Today is the day and time set for the second hearing in this matter. Mr. Morton, what is the rent to retain possession?
If I may, Your Honor, actually was that I spoke to my client this morning. It sounds like Mr. Patton had made a large payment just recently. Does that sound correct, Mr. Patton?
Yes, I paid it in full yesterday.
Exactly. So was it the payment was just received yesterday and it cleared through? So we're going to be submitting a dismissal on this matter.
Any objection to the dismissal, Mr. Patton?
Nope, not at all. Thank you.
Thank you, sir. You're free to go. You have a wonderful day.
All righty, you too. Bye-bye.
Thank you. This is 2301116LT, Harbor Club versus Ronald Hunter.
Your Honor, for the record, Attorney Ian Morton of Palace Law on behalf of the plaintiff.
Ronald Hunter here.
Thank you. Today's the day and time set for the second hearing in this matter. Mr. Morton, what is the rent to retain possession?
Your Honor, rents retained are $1,393.00. Core costs of $172.33 for a total of $1,565.33.
Mr. Hunter, were you able to hear Mr. Morton just now?
Yeah, I heard Mr. Morton. I don't understand.
Is the amount of,
Go ahead. Go ahead.
you don't understand which part, Mr. Hunter?
Well, I spoken to the property manager over here, and I'm current as a money status, rental status. I'm really current, and I owe a fee because of I didn't sign a lease agreement, so I wasn't aware of a upcharge they charged me. So I'm current in rent. The total amount I owe is $1,663. That's what I agreed to pay to the property manager over here. That's what she came up with, and I'm current. So my monthly fee is $1,100. I owe that and a back pay of $563. So I don't know what's
Okay,
going on.
I'm sorry, Mr. Hunter, you indicate that you owe $1,663?
Yes.
Mr. Morton indicated that you owe $1,565.33.
Yes. I don't know. I really don't understand what's going on, why he got that number, but I know what I owe. I plan on paying my current bill. I really don't.
I believe that number is less than what he had quoted, Your Honor. Am I mistaken?
Well,
No, you're correct, Mr. Morton, which is why I'm asking Mr. Hunter. The attorney's office is saying you're owing less than what you say you're owing, Mr. Hunter. Mr. Morton, is there someone available that can meet Mr. Hunter in a breakout room and maybe go over this ledger? And if it remains disputed, we'll schedule the matter for hearing.
Well,
Certainly, Your Honor. What I could do, what might be best is I can speak to Mr. Hunter in a breakout room, and then I can have the other attorney that's here from my office step out and then handle the court. I don't think there's too many other. I still don't expect. I don't want to jinx anything. I don't expect any other contested matters. But what I'll do is I can speak to Mr. Hunter in a breakout room, and then I'll have Miss Miss Fontanella step out, and she can appear as people appear for you, Your Honor.
Thank you.
Absolutely. So, Mr. Hunter, I'm going to move you into a breakout room so we'll have an opportunity to be able to speak. Okay?
Please.
Mr. Callahan and Mr. Meek.
Yes, Judge. I think Mr. Meek is trying to speak to his client right now about my offer before we go on the record.
Thank you. Ms. Parak?
Yes, Your Honor. I'm sorry. I'm dialing in. My camera is not being recognized. I just moved offices last night, and my Zoom's not working, but I am here.
Thank you. Mr. Court is here for the defendant in this case. Do the parties need the opportunity to speak?
Yes, we do, Your Honor.
Marianne will get you into a breakout room to talk to one another.
Thank you. Your Honor, I don't.
This is 230113 LT. This is Harbor Club versus Lakeisha Phillips.
Good morning again, Your Honor. Sydney Fontanella, P86316 on behalf of the plaintiff.
Ms. Phillips,
Present.
turn your video on, state your name for the record, ma'am.
My camera isn't working. Hold on one second.
Today's the day and time set for the second hearing in this matter. Ms. Fontanella, what is the rent to retain possession?
Your Honor, there's current rent to retain of $4,536, court costs of $172.33 for a total of $4,708.33.
Ms. Phillips, were you able to hear the attorney just now?
If you could just repeat that last number, that would be great.
$4,708.33.
Okay.
Get out of there.
I'm sorry?
Yes, I heard the balance.
Someone else said something, Ms. Phillips. Is that amount of rent accurate?
Are you asking me that?
Yes, ma'am.
I'm trying to do the math on it right now. 3, 6. It appears to be accurate.
Ma'am, do you have any defense to this non-payment of rent action?
No.
Ma'am, inasmuch as you do not dispute the amount of rent claim due and owing, there is not a tribal issue of fact, and plaintiff is entitled to entry of judgment as requested. Ms. Fontanella's office will submit a judgment to the court that indicates that total amount due and owing of $4,708.33, and will indicate that you have until November 13th to pay that amount or vacate the property. Do you have any questions, Ms. Phillips?
No, I do not have any questions, but how many months are included in that how many months are in there? Because I'm just trying to make sure before we enter the judgment that this is accurate amount.
Your Honor, give me just a second while I pull up the ledger.
Thank you.
Excuse me. I was just in a meeting. I think I hit the wrong button. I'm sorry.
Your Honor, I'll handle that with Mr. Hunter.
Oh, okay. You're back. I didn't know what happened. Can I get back in the room with you or whatever?
He's trying to bring you back into that room, Mr. Hunter. Thank you.
Okay. I'm sorry.
Ms. Fontanella, while you do that, I'll call this other case 2301467 LT, Cooper Equity versus Heather Dolan.
And for the record, Judge Kevin Callahan, P78273 on behalf of plaintiff.
May it please the court, Jeffrey D. Meek appearing on behalf of and with the defendant, Heather Dolan.
Thank you. Today's the day and time set for the second hearing in this termination tenancy matter. How are we proceeding this morning?
Your Honor, it's our position that there is no tribal issue of fact here. There was a warranty deed to my client as of July of 2023. There is no lease agreement. There is no other agreement for the defendant to be here. We would ask for judgment.
Mr. Meek?
Yes, we were in a discussion with Mr. Callahan in a breakout room. I told him I needed to talk to my client for a minute, so I checked out of the breakout room. I went back in, and Mr. Callahan wasn't there. So I was trying to respond to his proposal. But we did file an affidavit.
Speak to each other. I'm sorry. If you need to speak to each other, Mr. Meek, we can put you into a breakout room, back into a breakout room.
Okay.
You can go back into room 20 where you came from.
Okay.
Thank you. Ms. Fontanella, did you get that number calculated for Ms. Phillips?
Your Honor, I just pulled up the ledger. It looks like she has not been at a zero balance since February of 2023. There's been quite a few partial payments accepted. So at this time, I can't say for certain how many months she is behind because of all the partial payments, and there's been no zero balance.
I mean, I guess I'm concerned with that statement, because there was, like, at the last court hearing, it had to be brought to zero to even not be evicted. And so I guess when was that last lump sum of a payment that is
Well,
reported?
Ms. Phillips, Ms. Phillips, the court inquired and you indicated that the amount of rent you thought was accurate. If you're disputing the amount of rent, what we can do is put this matter over. Have you reviewed the ledger?
Go ahead.
I was gonna say, have you reviewed the ledger and have witnesses sworn in and take testimony in this matter?
I don't think that would be necessary. I just want to, because I'm saying that the rent is accurate, and I'm not sure if the amount of rent is accurate before going on the record to say that I can have paid said cost by the 13th.
I know, Ms. Phillips, and I hear you, and that's why I'm saying we can put this matter over to the 15th of November. You'll have the opportunity to review the ledger.
Okay.
And then we'll take it up that way.
Okay, that works.
November the 15th at 9:30 a.m. And Ms. Phillips, you don't have to wait until that date to look at the ledger. I'm sure that you'll be able to get that information from Harbor Club, review it, and if the parties reach an agreement before the return date, just reduce it to writing. The attorneys know how to do that and get that filed with the court in lieu instead of appearing for a third hearing, okay?
Okay, thank you so very much.
Thank you, Your Honor.
Thank you, Ms. Phillips. Mr. Berncrant, I believe you have some tenants here available. What Marianne will do is, if she has not already, she'll make you co-host. You get your tenants in to meet with you. We're still on the 10:30 docket.
Okay, thank you very much, Your Honor. I'll move myself around.
Thank you. This is 2301106LT. This is Harbor Club versus Jordan Bauer.
Sydney Fontanella, P86316 for the plaintiff again, Your Honor.
Ma'am, state your name for the record.
Jordan Bauer.
Thank you. Today is the day and time set for the second hearing. What is the rent to retain possession, please?
Your Honor, rent to retain is $1,189. Court costs of $172.33 for a total of $1,361.33.
Ms. Bauer, were you able to hear the attorney just now?
Yes, I can.
Is the amount of rent claim due and owing accurate?
Yes.
Do you have any defense to this non-payment of rent case?
I do. More so that I can pay the balance. I called yesterday, and then the past balance is $366.65, and then plus what is due now for rent is that $1,357. I can clear that balance of $366 plus some of the rent, the current rent this Friday, but I can't give the full amount because that would be my full check, but then I can zero out on the next check that I receive.
Ms. Bauer, the issue is if the amount claimed is accurate, there's not a tribal issue of fact and the plaintiff is entitled to entry of judgment. The court does not get involved in the payment plans between landlords and tenants. The court would suggest that you reach out to the management office for any payment plan you might have. I heard you indicate that you had paid down significantly, and now with November being due, you are able to pay it off of the next two checks, but that's an arrangement you make with the property manager, the leasing agent, whatever they call them at Harbor Club, okay?
Okay.
Anything else, Ms. Bauer?
Not at the moment.
Thank you. The attorneys for the Palace Law Firm will submit a judgment with those dollar amounts on it. Make your payments directly to them. Okay,
Okay,
have a good day, ma'am.
thank you.
Thank you, Your Honor.
We're back on the record in 2301116 Harbor Club versus Hunter. I have your appearances. You've had the opportunity to speak. Mr. Morton, how are we proceeding?
No problem, Your Honor. The parties have spoken. We've agreed to enter into the proposed consent judgment agreement. We went over the numbers together. Rents retained $1,393.00. Court costs of $172.33 for a total balance of $1,565.33. As I told Mr. Hunter, this is inclusive of the month of November. Additionally, I did advise him his rights, which included the fact that this would not be final for 3 business days, and he had those 3 days to make a request for a new hearing date if he wished. Second, the fact that he has the right to appeal, and he did give me permission to put his name on the proposed consent judgment agreement, Your Honor.
Mr. Hunter, were you able to hear Mr. Morton just now?
Yes, ma'am.
Is everything he said correct?
Correct.
Do you have any questions, sir?
None whatsoever.
Thank you. Mr. Morton will submit a consent judgment signed by both parties to the court for entry with the terms that were just placed on the record. That concludes this matter, Mr. Hunter. Thank you for your patience in working through this. You have a wonderful day.
You too, ma'am.
Thank you. This is 2301109 LT Harbor Club versus Diane Chapman.
Good morning again, Your Honor. Sydney Fontanella, P86316 for the plaintiff.
Diane Chapman, this case being scheduled for second hearing at 10:30, it being 10:43 by the court's clock. Defendant having failed to appear, Ms. Fontanella, how would you like to proceed?
Your Honor, I am requesting a default judgment. May I go ahead and put the amounts to retain on the record?
Yes, please.
There's current rent to retain of $3,205.50. Court costs of $172.33 for a total of $3,377.83. I am requesting a default judgment with writ to issue in 10 days.
Thank you. The court will enter the default judgment with the terms just placed on the record. This is 2301111 LT Harbor Club versus Anton Dillard.
Sydney Fontanella.
Anton Dillard. I'm sorry.
Sydney Fontanella again for the plaintiff, Your Honor.
Thank you, Ms. Fontanella. Today is the day and time set for the second hearing in this matter. The case was scheduled at 10:30. It's 10:44 by the court's clock. The court hearing no response. Dillard, how would you like to proceed?
I am requesting a default judgment, Your Honor. There's current rent to retain of $1,956, court costs of $172.33 for a total of $2,120.33, writ to issue in 10 days.
Thank you. The court will enter a judgment with those amounts. This is 2301112 LT Harbor Club versus D'Angelo Funches and Annie Flesher.
Yes, I'm here, D'Angelo Funches. I've had a few court hearings, and I stated that Annie is like off the lease.
I'm sorry, sir. You were saying,
Yes,
I can't hear you.
Can you hear me now?
Yes, sir. You just were muffled.
Oh, I'm sorry. No, I stated in previous court hearings that Annie Flesher is off the lease. It's just been me.
Ms. Fontanella, what is the rent to retain possession in this case, please?
The rent to retain is $6,100, court costs of $210.75 for a total of $6,310.75, Your Honor.
Mr. Funches, were you able to hear the attorney just now?
Yes, and that wasn't the numbers I just heard on what was it, the 25th of October?
Your Honor,
So
Mr. Funches.
Yes, I'm here. I'm sorry.
No, you go ahead, sir.
Oh no, I was saying that is that including November's rent?
Your Honor, that does include November's rent.
You said it does or doesn't?
It does.
Okay, because when I was in the court hearing on the 25th, they said that the price that I needed to be, I mean that was due, that I wouldn't retain November's rent.
Mr. Funches, what we'll do right now, there are some other matters. We'll have you go into a breakout room. You'll go over these amounts with an attorney from the law firm, and when you come back out, I'll recall the case, okay?
Okay.
Your Honor, I'll
Thank
talk
you.
to Mr. Funches, this is Attorney Ian Morton, and then I'll let Ms. Fontanella continue with the rest of the matters.
Thank you. This is 2301113 LT Harbor Club versus Green.
Sydney Fontanella for the plaintiff, Your Honor.
Janiyah Green. Second hearing in this case was scheduled at 10:30. It's now 10:48 by the court's clock. Defendant having failed to appear. Ma'am, how would you like to proceed?
Your Honor, I am requesting a default judgment. There's current rent to retain of $3,466, court costs of $172.33, for a total of $3,638.33, writ to issue in 10 days.
Thank you. Please have your office submit the judgment by default. The court will enter it with those terms. This is 2301114 LT Harbor Club versus Stephanie Hodges.
Sydney Fontanella for the plaintiff.
Stephanie Hodges. Today is the day and time set for the second hearing in this matter. The case was scheduled at 10:30. It is now 10:48 by the court's clock. Defendant having failed to appear. How would you like to proceed?
Your Honor, I am requesting a default judgment. There's current rent to retain of $4,841.70, court costs of $172.33, for a total of $5,014.03, writ to issue in 10 days.
Thank you. Please have your office submit the default judgment with those terms, and the court will enter the same. This is 2301117 LT. This is Harbor Club versus Tyreek Hunter.
Sydney Fontanella for the plaintiff.
Tyreek Hunter. Today is the day and time scheduled for the second hearing in this matter. Case was scheduled at 10:30. It's now 10:49 by the court's clock. Defendant having failed to appear, ma'am, how would you like to proceed?
Your Honor, I am requesting a default judgment. There's current rent to retain of $1,699.49, court costs of $172.33, for a total of $1,871.82. I am requesting writ to issue in 10 days.
Thank you. Have your office submit the default judgment with those terms, and the court will enter the same. This is 2301120 LT Harbor Club versus Ali Khalif and Kristen Khalif.
Sydney Fontanella for the plaintiff. Your Honor, I am requesting that this case be dismissed without prejudice.
The court will do that. Thank you, ma'am. This is 2301125 LT Harbor Club versus William Morgan and Willie Morgan.
Sydney Fontanella for the plaintiff, and Your Honor, I am requesting that this one also be dismissed without prejudice.
Thank you, Ms. Fontanella. This is 2301137 LT Harbor Club versus Lakira Thomas.
Sydney Fontanella for the plaintiff, and I am requesting that this be dismissed without prejudice as well, Your Honor.
This case will be dismissed. Thank you, ma'am.
Thank you, Your Honor.
This is a recall of 2301467 LT Cooper Equity versus Heather Doan.
And for the record, Your Honor, Kevin Callahan for plaintiff.
May it please the court, Jeffrey D. Meek on behalf of defendant.
Unfortunately, at this time, Judge, we do not have any kind of settlement or arrangement, and we look to the court.
Mr. Meek?
Yes, Your Honor, we filed an affidavit yesterday. I don't know if Your Honor had a chance to read it.
How did you file that affidavit, Mr. Meek?
Yes, we filed an affidavit because plaintiff's counsel sent me a motion, and it didn't have a hearing date on it, and I couldn't discern the hearing date. I ended up talking to the clerk, found out that he never filed the motion with the court, but by that time I had filed an affidavit. I just got the motion yesterday because I was out of town over the weekend for my son's wedding in Chicago. And anyway, as the affidavit states, my client had an agreement with her stepfather to purchase this house. And she had been making payments for 18 years on this house. She put a new roof on it. She put a new furnace in it, a new water heater, a new pool liner. She maintained it. This went on for years. And the deal was she paid him every month. And then the amount of the payment was the amount of the mortgage on the house. When the mortgage was paid off, then she was to get title to the house. And this arrangement was reaffirmed a year or so ago when a neighbor was erecting a fence, and my client thought he was putting it on, her property. And she notified her stepfather. Stepfather said, well, you deal with it. It's your problem. You're buying the house. That's all in the affidavit. My client's got over $200,000 that she's put into this house. She's been in possession the entire time. And there's an abundance of case law. I really would like to brief this issue to the court. I happen to do quite a bit of real estate law, and there's an abundance of case law that says that a tenant in possession is notice to any buyer. It's constructive notice of their rights. And there's a case that's been cited repeatedly, Hall versus Gafil Oil Company. It's an opinion by Justice Henry Butzel, very prominent Michigan justice, of course. And in there, the court held that if there's a tenant or someone in possession, even if it's an oral arrangement, that the purchaser is on constructive notice of their interest, and that purchaser has got, the court says, in the instant case, plaintiff knew that defendant was in possession, that there were valuable improvements on the premises. Here we even had a pool, specifically adapted to defendant's uses. It was no hardship for her to inquire, her being the buyer, as to whether there were any other modifications or changes in the lease. Ordinary business prudence should have prompted her to do so. And then he goes on and talks about how leases can be modified and that the buyer is on constructive notice of the tenant, and that they have a duty to inquire of the tenant and find out what the total arrangements are, what their rights are, if there's an option to purchase. And then Justice Butzel cited another case from out of state, Dengler versus
Mr.
Fowler.
Meek.
And I really would like to brief this. We've made
Mr.
a
Meek,
jury demand.
respectfully, if you want the opportunity to brief that, then let's set a date for the parties to return. The primary concern that I have is that there was a jury demand made in this case.
Yes.
And if that's the direction we're going in, I want to start to get a schedule to go in that direction.
I agree 100%, Your Honor.
And Mr. Callahan, Mr. Meek referenced a motion that you filed.
Yes, Judge. We filed a motion. We sent it to the court by mail. Unfortunately, now that the court is e-file, I don't know if the court's going to reject that or not and force me to file it via e-file. And that's what Attorney Meek references as far as I never filed it. I sent it to the court for filing. However, I don't think it ever got filed because of the e-filing system now, Judge.
Mr. Callahan, what is the nature of your motion?
It's a motion pursuant to 4.201J2. There is no triable issue of fact here to go to the trier of fact, and we're asking for judgment today. There was a warranty deed that was issued from Benjamin Young, the previous owner, to my client back in July of 2023. Everything that Attorney Meek says is great. However, it has no relevance to this case at all because there is no residential lease. There was no lease in place. As the court knows, any oral arrangements to purchase property is invalid pursuant to the statute of frauds. Any issue that Ms. Doan, the defendant, has with her stepfather for selling the house between her and her stepfather, Judge. Yes.
Mr. Callahan, you're talking about a motion that the court hasn't seen. The court's happy to take it up, not right now without the written motion. And the question to you, Mr. Meek, is how long will it take you to file your response to the motion?
I can have it briefed within 10 days.
10 days from today puts us on the 11th. Can we set the hearing date independent? I don't want to put you on with anything else. How does November 17th look?
Looks good.
I have no objection to that, Your Honor. The only thing I would say to that, because there is a jury demand, thank you for rolling your eyes, Mr. Meek. That's very professional of you. The only thing that I would ask, Judge, is for an escrow order to enter here, because there is a jury demand, and because my client now is being prejudiced by the actions of Attorney Meek. I would ask for an escrow order to enter for the month of November.
The escrow order will enter beginning today. Mr. Meek, your client will need to post that escrow amount of how much, Mr. Callahan?
I believe what she claims that she was paying was $890. That's what I would ask for.
And Mr. Callahan, submit that escrow order. The court will sign it. Mr. Meek, have your client post the escrow amount with the court. We'll schedule the matter for hearing on Friday, November the 17th at 9 a.m. It's the only thing this court has scheduled. Mr. Callahan, if the court, I didn't see a motion from you, so if you would either e-file it, or if it has not been rejected, the hard copy hasn't been rejected, I'll need to hunt it down. Mr. Meek, get your response filed. We'll have you back here on Zoom on November 17th at 9 a.m.
Thank you, Judge.
Okay. And by the way, Your
Anything
Honor,
else, Mr. Callahan? I'm sorry.
right.
Anything else, Mr. Callahan?
Nothing further, Judge.
Anything else, Mr. Meek?
Yeah. He didn't file a notice of hearing, so I had no idea when this motion was going to be up. So there's that. And furthermore, they only paid $76,000 for the house that the city's got assessed for more than double that, over $100,000 more. So they bought it on the cheap. So $890 a month on a $76,000 investment is pretty generous.
Mr. Meek, are you objecting to something I've just said regarding our scheduling of going forward?
No, not at all.
Okay. And we'll take some of your issues up next Friday, 2 Fridays from now on the 17th.
Okay, thank you, Your Honor.
Thank you, Judge.
Thank you. This is 2301856 LT 15746 Meadow versus Adisa Abada.
Good morning, Your Honor. Raymond Court appearing on behalf of defendant Adisa Baba. She is present on Zoom.
Yeah, I know the attorney is here for the property.
Yes, looks like she's on mute.
Your Honor, can you hear me?
Yes.
Okay. I'm sorry. I'm not used to this one. Yes, Kathleen Proctor, Honor, P7804 on behalf of the plaintiff.
Today is the day and time set for the second hearing in this matter. How are we proceeding this morning?
Your Honor, Mr. Opposing Counsel has asked to look at the ledger and he needs to go over it with his client. I did email it over to him this morning, so we'd like a brief adjournment if possible.
Brief, like a week from now, brief?
Yes, please.
Mr. Court, are you available next Wednesday, the 8th at 11 a.m.?
I am.
I will see you back here on the 8th at 11 a.m. back on Zoom. Anything else, Ms. Baraka?
No, Your Honor. Thank you.
Anything
No.
else in this matter, Mr. Court?
No, Your Honor. Thank you very much.
Thank you. That concludes this matter. Have a good day.
You too. Thank you, Judge.
Thank you. I see parties here for the 10:45 call. I will take a brief recess. If there are parties that need to speak to each other, please go and do that. I will be right back. Mr. Morton, I'll take up the matter with you and Mr. Funches when I get back. I'm literally 2 minutes, so people, please don't go far.
Understood, Your Honor. Thank you.
Well, you said how long? Because I do have to get back to work, so that's what I was just trying to do.
2
Mr.
minutes.
Funches,
2 minutes.
2 minutes. Trust me, 2 if you let me go.
Okay.
Thank you.
Okay.
Oh, go in the pool. Trying to call me, did y'all?
This is a recall of 2301-112LT Harbor Club versus Funches. I have your appearances. How are we proceeding?
Your Honor, for the record, Attorney Ian Morton of Pallets Law on behalf of the plaintiff. Parties have spoken. We've agreed to enter into proposed consent judgment. Rents retained are $6,100. Court costs of $210.75 for a total of $6,310.75. Was it advised him of the payment date of the 13th of this month? Was it he will be reaching back out to Wayne Metro? I also did advise that was it Mr. Funches of his rights underneath the law, which includes the fact that this agreement would not be final for 3 business days. The fact that he has the right to appeal the matter, and he did give me permission to put his name on the proposed agreement, Your Honor.
Mr. Funches, did you hear Mr. Morton just now?
Yes, I did.
Is everything he said accurate?
Yes, ma'am.
You wish to enter a consent judgment that Mr. Morton will sign on your behalf and file with the court?
Yes.
And sir, you understand your rights in this matter?
Yes, ma'am.
Do you have any questions, Mr. Funches?
I did have one question. As far as the extension from the 13th, like, could I get it pushed out any more days from that or no?
Pushed out to what, sir?
So, because the 13th is, I'm trying to see.
The 13th is 2 Mondays from now.
Till that following Friday, the 24th.
Mr. Morton?
Your Honor, as I advised Mr. Funches, was it at this time, based on the balance, my client is going to want to move forward with the 13th date. Depending on what assistance, what payments he's able to come up with, they would reconsider that. But right now, they do want the 13th.
Okay.
Anything else, Mr. Funches?
No, that is it. Thank you both.
Thank you. That concludes this matter, sir. You can go back to work. Have a good day. Thank you for your patience.
All right, you too.
Thank you. Ms. McLemore, did you ever get a chance to speak to the representative from Mr. Levine's office for Alicia Messer?
Your Honor, Ms. McLemore is in the breakout room
I
with
see.
Ms.
Thank you,
Ms.
Mr.
Kirby.
George.
Yep.
This is 2300486LT MSR Holding versus Jamie Usher and all occupants.
Good morning, Your Honor. Afamba Packer on behalf of MSR Holding LLC.
Jamie Usher. Today is the day and time scheduled for the second hearing in this matter. Defendant failed to appear at the first hearing. This case was scheduled at 10:45. Today is 11:06 by the court's clock. Defendant has failed to appear again, sir. How would you like to proceed?
Your Honor, we'd request entry of a default judgment. The amount
Rent to retain
is $4,650. There is an unpaid water bill in the amount of $168.98. And the statutory costs and attorney fees of $232. My client did request a money judgment, but I do see the service was effectuated by posting. So this would just be a possession only with rent to retain. $5,050.98 is the total balance here.
Thank you. Please have your office submit a default judgment with those terms. The court will sign it. Thank you.
And I'm sorry, writ date of the 13th of November. Forgot to put that on.
Yes, sir.
Thank you.
This is 2301465 LT Merriman Plaza versus BPS Property 7620 Merriman Subway and Think Fresh Restaurant.
Good morning once again, Your Honor. Fonba Packer on behalf of the plaintiff.
Attorney Randy Ottish on behalf of the defendant.
Your Honor, between last hearing and this hearing, we have agreed to settlement terms. We have a settlement agreement that's been proposed, and I've recommended my client accept, and I do believe that they will be accepting it. We're asking for a 30-day adjournment. We are seeking to dismiss this case as the settlement calls for dismissal, and we think that that will happen within the next 30 days.
Not 30 days, more like 2 weeks of adjourning this matter, sir, because this court will be on the criminal docket in 30 days.
Okay. I'm not sure if we'll be completed by 2 weeks, but okay, that's fine.
I thought it was just the settlement document you were trying to work out.
No, there's the payment, the settlement calls for a payment that won't be made, I don't believe, within 2 weeks. So
the settlement agreement calls for a payment to be made no later than the end of the month, Your Honor.
Yes.
And once that payment is made, the case would be dismissed.
Then we can put the matter over to December 13th.
That's
not
okay.
30 days. It's a little bit longer, if that's okay with you.
That's okay.
That's fine. It'll definitely be concluded.
Yeah, I do believe that this will be done, and it'll save our clients money for us having to come back for another hearing.
Thank you. Please get your settlement document submitted to the court. Anything else on behalf of the plaintiff?
No, Your Honor.
Anything else on behalf of the defendant?
No, Your Honor.
Thank you.
Thank you.
Anything else, Mr. DeBacker?
Nothing else. That was my last case today. I appreciate it.
Thank you, sir. Have a good day.
You too. Bye-bye.
This is 2301113 LT. This is Harbor Club versus Green.
Present.
Turn your video on. State your name for the record, ma'am.
Janiyah Green.
Ms. Green, your case was scheduled at 10:30. Your chat to the court staff indicates that you were in the wrong Zoom room. The case
Yes.
was called at 10:47, and the attorney for the plaintiff indicated at that time that there was past due rent of $3,466. They were requesting court costs of $172.33 for a total judgment of $3,638.33. Is that amount of rent an accurate amount of rent, ma'am?
I'm not entirely sure. So for being past due, I did pay at least, I gave them like $2,100 already.
Miss Green, what I'll ask you to do is sit tight for 1 second. I'll see if Marianne, if you're able to get somebody from Pallets back on. They had been here all morning, ma'am. So just mute yourself. We'll see if we can get the attorney back on, okay?
Okay, thank you.
Thank you. This is 2301182 LT Gateway versus Tiffany Davis.
Yes, good morning, Your Honor. John Berncrant for Gateway Townhomes.
Good morning again, Your Honor. George of Lakeshore Legal Aid on behalf of Tiffany Davis, who is present on Zoom.
Good morning.
Thank you. How are we proceeding, Mr. George?
Your Honor, by the skin of our teeth, we managed to negotiate a conditional dismissal at the very last minute. The back rent that is currently owing is $570. Court costs of $166 for a total of $736. November rent is not being included in this because it is being paid through Section 8. So we're just dealing with the arrears here. And payments are as follows. Defendant shall pay $200 on or before November 3rd, $200 on or before November 10th, $200 on or before November 17th, and a final payment of $136 on or before November 24th. Each of those payments will be due by 5 p.m. local time on the due date. And I specified local time because we do have time change coming up. 4B is checked. Partial payments will not prevent an eviction. And if any of those payments are missed, then the plaintiff will be able to come back, file an affidavit of default, set this agreement aside, and proceed with the eviction.
Was that an accurate recitation of your agreement, Mr. Burnkrant?
It is, Your Honor, and we've both signed it, and I will submit it to the court following the hearing.
Thank you. I'll await receipt of it, Ms. Davis. Once I receive it, I'll sign it and get it back out to the parties. Anything else on behalf of the plaintiff?
Nothing further, Your Honor. Thank you.
Nothing
Anything
further.
else
Thanks.
on behalf of Ms. Davis?
No, thank you.
I'm sorry, ma'am, you said something?
No, I didn't.
That concludes this matter, Ms. Davis. You're free to go. Thank you for your patience.
Thank you. I appreciate it.
Thank you very much. And you have a wonderful day, Your Honor.
Thank you, too, sir. This is 230-1199 LT. This is Gateway Townhomes versus Amber Davis.
John Berger, Gateway Townhomes, Your Honor.
Good
State
morning.
your name for me, please, ma'am.
Amber Davis.
Today's the time set for the second hearing in this matter. Mr. Burnkrant, how are we proceeding?
Yes, Your Honor. I've talked to Ms. Davis, and we've agreed to the entry of a consent judgment for possession only. The rent portion would be $3,044, and then there would be costs of $166 for a total of $3,210. $3,210 to be paid on or before November 13, 2023. Otherwise, she would need to vacate the apartment by that date. She also has agreed for me to sign her name to such a consent judgment. And I've also indicated to her that she has 3 business days to come back to court and ask Your Honor to set aside this consent judgment, and it'll be up to the court as to whether a trial would be granted. And I've also indicated she can have 30 days in which to appeal this to a higher court.
Ms. Davis, were you able to hear the attorney just now?
Yes, Your Honor, I was.
What was everything he said correct?
Yes, it is.
You wish to enter a consent judgment that you'll allow his office to sign on your behalf and file with the court?
Yes, Your Honor.
Do you have any questions, Ms. Davis?
No, I do not.
Thank you, ma'am. I'll wait receipt of the paperwork from the attorney's office. Other than that, you're free to go. You have a good day.
You too. Thank you.
Thank you. This is 2301227 LT, Huron Estates versus Alicia Messer.
Good morning, Your Honor.
Good morning, ma'am.
Jeanette McLemore. I'm here on behalf of Ms. Messer, and I believe Ms. Messer is Blue G33. That's also on the Zoom call.
I'm here. Sorry, it keeps kicking me out, you guys. I apologize. I'm trying to get this under control. It keeps wanting to download the Zoom.
Your Honor, I just filed an appearance in this case this morning, Your Honor, so it may not have reached your file yet.
And Your Honor, Laura Karubi on behalf of plaintiff.
Thank you. How are we proceeding this morning?
I'm sorry, go ahead.
That's okay. Okay. We did have a chance to speak, Your Honor, and at this time, Ms. McLemore is requesting an updated ledger. The property manager, my client, is here, and I did provide her with Ms. McLemore's email address, so she will be sending that over today. So at this time, we would like to request a hearing.
Yes, Your Honor.
Ms. McLemore, I don't remember from this morning. Are you back on the 15th or the 8th?
I am back on the 15th on another matter, Your Honor.
I'm sorry to interrupt, but can you guys hear me?
Yes, ma'am.
Okay, this is Alicia Messer. It keeps kicking me off. I don't know what to do.
You're fine, Miss Messer.
Okay,
November 15th at 10 a.m.
Yes, that would be good for me, Your Honor.
That is fine with me, Your Honor. Thank you.
Thank you. I will see you then. Anything
Thank you,
else
Your
on behalf
Honor.
of the plaintiff?
Not for this matter, Your Honor.
Anything else, Ms. McLemore?
No, thank you, Your Honor.
Thank you, ma'am. Have a good day.
You too. Bye-bye.
This is 2301266 LT. This is Balfour Industries versus T. Abuxa and Tariq Abu Asa and Namir Barakat.
Good morning, Your Honor. Troy out on behalf of the plaintiff.
Is there any? Today is the day and time set for the second hearing in this matter, Mr. Otto. It appears that the defendants failed to appear at the first hearing and failed to appear again. How would you like to proceed this morning?
Your Honor, I would request a possession-only judgment in the amount of $22,500. This is a commercial property. Rent was $4,500 a month. There's 5 months of unpaid rent with a writ date of November 13th.
Have your office submit a default judgment by my file. Court will
Okay.
sign it, mail copies back to the parties. Have a good day. Thank you for your
Thank you.
patience.
No problem. Thank you.
This is 2301200 LT. This is Gateway versus Roots and Roots.
Your Honor, John Bergman for Gateway Townhomes. I would move to dismiss this matter without prejudice. I will be submitting that right after the hearing.
Thank you, sir. 2301201 LT, Gateway versus Latoya Rush.
John Bergman again for Gateway Townhomes. She should be here.
Here.
Turn your video on and state your name for the record, please, ma'am. Today is the day and time set for the second hearing.
My name is LaJoya Rush.
Thank you. Mr. Bernkran, how are we proceeding in this matter?
Yes, Your Honor. I have met with Ms. Rush and we have agreed to the entry of a consent judgment for possession only. The rent portion is $3,087. The court costs are $166. The total redemption number would be $3,253 to be paid by no later than November 13, 2023. Otherwise, she would need to vacate the apartment by November 13, 2023. I've explained that she has 3 business days to come back to court and ask the court to set aside such a consent judgment, and it would be up to the court to grant a trial at that point. I've also indicated that she has 13 days in which to appeal this to a higher court. She has also agreed to allow me to sign her name to such a consent judgment.
Ma'am, were you able to hear the attorney just now?
Yes, ma'am.
Was that your understanding and agreement?
Yes, ma'am.
Do you have any questions at all?
No, ma'am.
His office will submit a judgment with the terms just placed on the record. The court will sign it and a copy will be mailed to you at the address we have on record. Have a good day, ma'am. You're free to go.
Thank you. You as well.
Thank you. Mr. Morton, we had Miss Green appear. She had been in the wrong room. Do you have a moment to speak with her?
Absolutely, Your Honor. I will move
Thank
her
you.
to
We'll
a
get you
breakout
into
room
a
and speak
breakout
with her.
room.
Yep.
This is 2301225 LT, Huron Estates versus Brian Phillips.
Laura Kruger, Your Honor, for the plaintiff.
Brian Phillips. Today is the day and time set for the second hearing in this matter. Defendant failed to appear at the first hearing, has failed to appear at this hearing. How would you like to proceed, ma'am?
Your Honor, at this time, plaintiff would like to move forward with a default judgment for possession only, rent to retain in the amount of $3,282.71, court costs of $168.28 for a total of $3,450.99, with a writ to issue in 10 days.
Thank you, ma'am. Have your office submit that judgment for entry.
Thank you.
This is 2301244 LT. This is Gateway Townhomes versus Outlaw and Burns.
John Bergman for Gateway Townhomes, Your Honor.
Yo. I'm here.
Turn your video on and state your name for the record, please.
My camera broke. Marquise Outlaw.
Mr. Bernkran, how are we proceeding in this matter?
Yes, I've talked to Mr. Outlaw, and he has agreed to a consent judgment for possession only. The amount of rent owing is $3,657. Court costs of $202 for a total redemption figure of $3,859 to be paid by no later than November 13, 2023. Otherwise, he will need to vacate the premises by that date. The other tenant, co-tenant, Khadijah Barnes, is not here today. She was not at the last hearing either. Apparently, she's already moved out, according to Mr. Outlaw. So I would ask for a default judgment enter against her, and Mr. Outlaw has no objection to that. And I've explained to Mr. Outlaw that he has 3 business days to come back to court and ask Your Honor to set aside the consent judgment. And at that point, it would be up to the court to grant a trial or not. And also that he has 13 days in which to appeal this to a higher court. He's authorized me to sign his name to such a consent judgment.
He said everything.
Mr. Outlaw, were you able to hear the attorney just now?
Yeah, he just said everything except that I moved out already. I don't understand that part, why he ain't mentioned that. But yeah.
You moved out when, sir?
Yesterday.
Your Honor, the difficulty is that
I don't know why he mentioned everything but that, but I understand everything else.
If I may respond, Mr. Outlaw, I explained to you that you told me.
I know, but you went over everything.
Hold on.
That part.
Mr. Outlaw, I can only hear one person at a time. Give me 1 second. Sir, Mr. Burnkrant.
Thank you, Your Honor. I explained to Mr. Outlaw, he told me he has not turned in her keys. I've talked to our manager as recently as within the last hour, and there was no indication that he had moved out. So I told Mr. Outlaw that if in fact he has moved out, he would need to remove all of his belongings and he'd have to surrender his keys, which is symbolic of returning possession. And also, of course, Ms. Barnes is not here as well today. So that he says he's going to turn in his keys today. I don't know that. And I'm not there to be present to see if he cleaned out his apartment. So we haven't gotten to that point yet. I also explained it's just a possession judgment and not a money judgment.
Mr. Outlaw, the court's question to you was going to be, had you turned your keys in? And if the answer is no, keys equal possession. And as long as you have those keys, you are deemed to be in possession of the premises.
Y'all done?
Yes, sir.
Okay, thank you.
Was there anything else you wanted to say, Mr. Outlaw?
I was done talking a long time ago.
Thank you, sir. You're free to go. You have a good day.
Your Honor, I do have one other case that may be on your docket. I'm not sure of it because I did submit a judgment, a default judgment on quite some time ago. Is 23-01247 LT.
2301, I'm sorry.
01247. Passion Cook is the defendant. And I have not received the judgment back from the court. I e-filed it on October 25th. I'm not sure. I think it might be appearing.
I don't see it. Give me 1 second, sir.
Thank you, Your Honor.
23-01247.
Correct.
Excuse me, Judge, it's closed in JIS.
I'm looking. Yes, Mr. Burnkrant, the judgment was signed on October 26th.
Oh, I was unable to pull it electronically to see that. Okay, I will try again. Thank you, Your Honor.
Thank you, sir.
Have a good day.
You too. This is 23-01235 LT. This is Huron Estates versus Victoria Cassida and Caleb Cassida.
Hello,
State your name for me, please, ma'am.
my name is Victoria Cassida.
Ms. Cassida, have you spoken with the attorney from Huron Estates this morning?
No.
She appears to be in the breakout room with someone else. If you sit tight, as soon as she comes back out, we'll get you connected.
Alrighty, thank you.
Thank you. Ms. Hodges?
Yes.
Ma'am, your case was scheduled at 10:30. It was called at 10:48.
Yes, I do apologize. I was in the wrong waiting room. I was in the waiting room for Westwood Village.
You were in the wrong waiting room or you were in the wrong Zoom room?
I was in the wrong Zoom room.
Did the court give you the wrong number?
I was not given a new number upon my first hearing.
Ma'am, the attorney's office was here and indicated that the past due rent was $4,841.70. They were requesting court costs of $172.30 for a total of $5,014.03. Is the amount of rent claimed due and owing accurate?
Yes, I don't have any other way of viewing that, so I believe so.
I'm sorry, you said you don't have any way of doing what, please?
Of viewing the amount, so I believe so. I'm not sure what's the correct amount at the moment.
Are you disputing that amount of rent? That $4,841.70 in rent is due and owing?
No, I'm not. I'm just, I know today is the 1st. I believe the original amount I was given last week was a total of 3,000. However, I don't know if that's just the cost as of right now because today is the 1st. However, it is close to the amount that is owed.
Ma'am, if you're not disputing the amount of rent, there's not a tribal issue of fact and the court will enter judgment. If you are disputing the amount, that's a different story. That's why I'm asking you.
No, I am not disputing it at all.
Okay, then Mr. Morton's office, the attorney for Mr. Palace's office is already submitting a default judgment with those amounts based on the court having called the case earlier, but he is here now. He will note Ms. Hodges, Stephanie Hodges from 2301114 LT did appear. And you will get a copy of the judgment in the mail, ma'am. Did you have a question, Ms. Hodges?
Yes, I do. So I do not have a chance to speak with him at all.
You do, ma'am. But
Okay.
you're telling me that you agree that the amount of rent is accurate. So if you
Yes,
sit
yes.
tight, give me a moment. I'll call another case and then I'll send you in with Mr. Morton. He's already been gone for the day, so he's back as a courtesy to the court, and I don't want to commit his time.
Okay.
But if he's here and available, I will get you into a breakout room with him, okay?
Okay, thank you.
And
Thank you. This
Your
is a
Honor,
recall of,
I was gonna say, I'll certainly speak to Ms. Hodges after we put Ms. Green on the record.
thank you, Mr. Morton, 2301113 LT, Harbor Club versus Green.
Your Honor, for the record, Attorney Ian Morton of Palace Law on behalf of the plaintiff. The parties have spoken. They've agreed to enter into a proposed consent judgment. Rents retained are $3,466. Court costs of $172.33 for a total of $3,638.33. As I advised Ms. Green, this includes the month of November. We've agreed to a slightly extended payment date of 11/17. Additionally, Your Honor, I did advise Ms. Green of her rights in regards to the fact that A, this agreement would not be final for 3 business days. 2, the fact that she does have the 10-day time period to appeal. And 3, and additionally, she provided me permission to put her name on the proposed consent judgment agreement, Your Honor.
Ms. Green, were you able to hear Mr. Morton just now?
Yes.
Was everything he said accurate?
Yes.
And that is the consent judgment you wish to enter into?
Yes.
His office will submit that consent judgment to the court. The court will sign it and a copy will be mailed to you at the address we have on record.
Okay, thank you.
Have a good day, Ms. Green. You're free to go.
You too.
Thank you. Ms. Hodges, you'll see an invitation to go into the breakout room with Mr. Morton. Please go there with him. This is 2301234 LT Huron Estates versus Henderson and Henderson.
Laura Kubi for the plaintiff. I believe she's still in the room 17, Your Honor. You want me to grab her?
Now, I don't want you to leave. I'll call your other cases while Mary Ann moves her out.
Okay.
This is 2301239 LT. This is Huron Estates versus Tammy Ball.
Laura Kubi for the plaintiff.
Today is the day and time set for the second hearing in this matter. This case was scheduled at 10:45. It's now 11:32 by the court's clock. This is the defendant's second failure to appear. How do you wish to proceed?
Your Honor, plaintiff wishes to proceed with a default judgment for possession only, rent to retain in the amount of $2,191.44 plus court costs of $168.28 for a total of $2,359.72.
Default judgment will enter with the terms just placed on the record. This is 2301233 LT Huron Estates versus Olivia Lloyd.
Laura Kubi, Your Honor, on behalf of plaintiff.
Today was the day and time set for the second hearing in this matter. The case was scheduled at 10:45. It's now 11:33 by the court's clock. Olivia Lloyd, this is the defendant's second failure to appear in this matter. Ma'am, how would you like to proceed?
Plaintiff would like to proceed with a default judgment, Your Honor, for possession only, with rent to retain in the amount of $6,439.12, court costs of $168.28 for a total of $6,607.40.
Court will enter default judgment with those terms. Thank you, ma'am. This is 2301234 LT Huron Estates versus Carol Henderson and Holly Henderson. Your appearance.
Holly Henderson here.
Laura Kubi on behalf of plaintiff.
And where is Carol Henderson?
She's currently in the hospital recovering from hip surgery.
Thank you, ma'am. The parties did have the opportunity to speak. How are we proceeding this morning?
Your Honor, I did have a chance to speak to Miss Carol Henderson. Or is that Holly? Sorry, Holly Henderson.
Holly.
And she has agreed, along with management, for a consent judgment with some terms. The rent to retain is $5,056.43 plus court costs of $204.91 for a total of $5,261.34. Ms. Henderson has agreed that she will pay first payment of $1,000 on November 3rd, payment of $1,500 on November 17th, a payment of $1,500 on December 1st, and a final payment of $1,261.34 on December 15th. And as such, defendant waives the 56-day rule. And as Ms. Carol Henderson did not appear, I would like to request a default judgment with the same terms as well.
Ms. Henderson, you were able to hear the attorney just now?
Yes, ma'am.
And ma'am, what she said is factually accurate in terms of the agreement reached by the parties.
Yes.
And that's how you wish to proceed?
Yes, ma'am.
And because you appear by Zoom, there's not a signed consent judgment with these terms. Have you authorized her office to sign your name to the consent judgment with these terms?
Yes.
And ma'am, you understand the rights you waive by entering to this consent judgment?
Yes, ma'am.
Do you have any questions, Ms. Henderson?
No, I do not.
Plaintiff's office will submit a judgment with those payment terms. Copy will be mailed to you once it's been signed. You have a good day. Thank you for your patience this morning.
Thank you.
This is Ms. Cassida did appear. This is 2301235 LT Huron Estates versus Cassida and Cassida.
Laura Kubi, Your Honor, on behalf of plaintiff.
I'm still here.
Thank you. And their rent to retain possession in this second hearing?
Rent to retain, Your Honor, is $2,351.99 plus court cost of $204.91 for a total of $2,556.90. Yes.
Ma'am, were you able to hear the attorney just now?
Yeah, for the totals.
Is the amount of rent claimed due and owing accurate?
Yes.
Do you have any dispute or any defense to this non-payment of rent action?
I mean, I really just lost hours recently. My dad just got evicted at the beginning of October. So I lost a bunch of hours trying to get him situated. He's handicapped and he's an amputee. But I've been recently picking up more hours at work, so I'm hoping to have the entire balance, including November's rent, paid off by the 22nd of November. That's the last payday I have in November. And I do understand there would be like a late fee, an additional like 50, or I forget how much exactly, but there will be an additional fee, I know.
Ma'am, are you able to extend the writ date?
Your Honor, the manager was here, but I don't know what happened to her, and I don't have any authority to extend the writ date at this time without her permission.
Ms. Henderson, I'm sorry, Ms. Cassida?
Yeah.
The court does not typically get involved in payments by and between the parties in landlord-tenant cases. So the court will find that there is no tribal issue of fact and enter judgment as requested by the plaintiff. What I will recommend that you do is be in direct contact with the management office regarding a payment plan. Although they might not typically take payments while the case is pending, now that a judgment is entered, that should change their position regarding this matter. And if for some reason they're unwilling to accept payments from you, you need only contact the court, make the court aware that they're refusing payments. And then the court will get involved in that portion of it.
Okay.
Do
I
you
can
have any
definitely
questions,
do
Ms.
that.
Cassida?
I'm so sorry.
I said, did you have any questions?
No, I can be in contact. I actually just got my phone service back today, so I can call them and try to work out a payment arrangement.
Thank you. That concludes this matter, ma'am. You're free to go. You have a great day.
Thank you. You as well.
Your Honor, I do have one remark. Can we move for a default judgment as to Caleb Cassida with the same terms?
Yes, ma'am.
Thank you so much.
Thank you.
Thank you.
Bye-bye.
I believe I am all set. Thank you. I hope you have a good
You are.
day.
Thank you so much, ma'am. Have a good day.
You too.
Mr. Morton and Ms. Hodges, my apologies for interrupting your conversation, but the court has a criminal case scheduled for this afternoon and wanted to take a small break. This is a recall of 2301114 LT Harbor Club versus Hodges.
Your Honor, was it, again, for the record, Attorney Ian Morton of Palace Law. I will advise the court that I did talk to Ms. Hodges. Was that we did speak about potential resolution. What I did provide Ms. Hodges, which appears that we are agreeable to, is I did agree that we can extend the payment date to the 17th of this month to November. She also proposed a longer term payment arrangement, which my client at this time is not agreeable to, but we will explore that. But in either way, she will have to the 17th to provide the balance, which was previously provided to the court. Which I can restate, but in its totality is $5,014.03. I was also explaining to her just some of her particular rights, which includes the fact that she does have the right to appeal any court decision to the higher court. Second, the fact that any agreement we enter into is not final for 3 business days. And so within those 3 days, if she felt confused or realized that she has a different defense, she has the right to make a request at a lower, standard to be able to request a new hearing date. And I would submit the proposed judgment to the court.
Ms. Hodges, were you able to hear Mr. Morton just now?
Yes.
And that's the agreement you wish to enter with him?
Yes.
Do you have any questions at all about these proceedings?
No, I do not at the moment.
Thank you. Mr. Morton's office will submit a judgment with the terms just placed on the record. The court will sign it. You'll get a copy in the mail. Thank you, Ms. Hodges. You have a good day.
You too.
Thank you, Your
Mr.
Honor.
Morton. That concludes this court's docket for the morning. We'll stand in recess until 12:30.